Hello, everybody. This is JD. I am now going to be talking to you about the current issue that's facing our Supreme Court and the way I feel about it. Now, this is the way I feel about it. And of course, that doesn't make it legal, it doesn't make it binding, but it does make it interesting. And there is a very important fact that we have to take in consideration. What is the Supreme Court making on this decision about same sex marriage? Well, actually, there's two separate issues here. One, marriage. Marriage is an institution established under God. Almost every state says, with the power and authority that state and God, or God and state, has given me. As soon as God is mentioned, it is a religious ceremony. And marriage it's a religious ceremony. And the Supreme Court is making a decision. Well, what do we do with marriage? Hands off. You cannot touch it. The federal government, the Constitution of the United States says that marriage is religious. And the Constitution in the First Amendment at the very beginning says that at the beginning of the First Amendment, that the federal government can neither support or defend, yea or nay, any established religion. In other words, the federal government can say nothing, one way or the other. Clear, cut, and dry. But you see, that's not the whole issue. There's a second half to the issue. And this is who can say what is a legal binding union between two people. Now, there is where we run into the real problem. Can the federal government recognize a union, which is a marriage, and then turn its back on another union of two people, saying, well, you're the same gender, so we can't recognize your union? Is that constitutional? Don't call it marriage, call it a union. That's what it is. Excuse me for moving this. I'm getting something out of place. What is the real issue that must be faced? What is the real matter? What is the real problem? Well, it comes down to this. The real issue, the real problem that the people are having is that some people get special privilege treatment in a legal union, legal binding union, that other people don't get just because they are of different genders. Now, here's where the federal government has some authority. What does the federal government accept as a legal binding union? Notice those words, legal and binding. Well, let me explain it to you this other way. Two people, it's a scenario I used. Let's say two female teachers had lived together because now they're 67, 68 years old. Their whole life. They had created a legal binding union between them. They bought a house together. They put savings together. They have done a lot of other things together, which shows that they are a union. But one of them gets very sick now. The other one calls 911 and the ambulance comes, take him to the hospital. Now, this person is extremely sick. And the other person, because the federal government doesn't recognize, or the state recognize that union, has nothing to say about the medical treatment of that sickly person. They find out, oh, there is a relative that lives somewhere else across the country, and the other person tells them of that, where they are. They try to contact that person. Well, in the meantime, waiting to get authority to do medical procedures, that elderly person dies. There's the other partner sitting there. Could have saved the life of her partner, but was unable because the state and federal government refuses to recognize that union. So here's where the real dilemma is. They're trying to make marriage as the definition of a legal binding union between two people. And they're trying to ignore all others. Can't do that. Equality. Then what do? Well, the federal government can issue unions, not marriage licenses, unions. Religious organizations will make it a marriage. A legal binding union can be between any two people and should be permitted. Let them fill out the paperwork and apply for a legal binding union, which must be dissolved if they wish to separate. They just can't walk away and say, well, I don't love you no more. I'm leaving. Goodbye. There's no commitment here. I'm out the door. No. Legal actions have to be taken to dissolve the union. Same thing with a marriage. That marriage license should be reworded so that it is authorizing the union of these two people to be seen as one by the government, and which will have all benefits that apply. Both federal and state. And they shall depend upon each other in their union. As such, there may be certain things that need to be stated within the union. But don't call it a marriage. Only a religious organization can perform marriages. When the state performs a marriage, it is actually performing a religious ceremony. Can it legally do that? That's up to the state and the state laws and how the state perceives it. But unions are another thing altogether. And all states should make available to all people the ability to have a union between two people. They could limit it to only be two people at one time, not a union between 3, 4, 5, or 6. But then down the road, who knows, maybe 4 people want to get a union and they're going to sue to get a union for 4 people. So there is some problem there. And it does need to be addressed. Because accepting a legal union between, let's say, 2 females. Well, why is it restricted only to 2 females? Maybe 3 females want it. Maybe 4 females want it. This has to be addressed. What they could say, it's a personal union that is required of 2 people and no more at one time. So the federal government and state would say we only recognize 2 people. Now, what happens if they want to get out of this union? They got to dissolve it. They have to go and get a lawyer and go to a court and dissolve the union. similar to a divorce proceedings, but it completely dissolves the union. And a divorce dissolves a marriage. If a religious organization says, hey, we acknowledge these two and we marry them, then that's the way it goes. Now you might say, well, is there any precedence for this? Yes, there is. There are people who marry different people in different states at one time. Now, the federal government only recognizes one. But let's say I get married in Virginia and I marry one woman, and I get married to a different woman in Maryland, a different woman in Washington, D.C., a different woman in New Jersey, a different woman in New York. When I'm in New Jersey, they will only recognize the marriage between me and the woman in New Jersey. They don't recognize the other marriages because they're not legal. They're not binding in their state. But a woman from Maryland can go to New Jersey and say, hey, he married me in Virginia and I am suing. The woman in New Jersey can't do it, but a woman from another state can. And I could end up in jail for polygamy. But what I'm trying to explain here is there is precedence for this, where the federal government and the state government recognizes only one union where there are multiple unions. These need to be looked at. Now, the truth is, marriage is a religious ceremony, and whether a state decides to or not, it's their responsibility. But the federal government has no authority when it comes to religious ceremonies. They can either say yes or no. But a union between two people, that is what needs to be addressed. That is what they need to decide on. What is a union between two people? What constitutes a union between two people? And how should this union be treated? Should the federal government treat the union similar, quote, similar to that of a religious marriage, or should it treat it as a union between two people given the benefits of that union? So really, the Supreme Court has two issues before it. One is marriage. The federal government has no authority whatsoever. It cannot say yay or nay to marriage. If a religious organization wishes to marry, if a state wishes to marry, they can do it. The federal government can say yes. If a religious organization says no or a state says no, they can do it. The federal government can't say one way or the other. But the federal government can say what is a union between two people and how they will be treated throughout the country. They have to define it, they have to explain it, and they would have to say what does the union actually allow or does. Hey, the lawyers will have a field day with that one. But the truth of the matter is, that's what's before the Supreme Court. Two issues. One, marriage, and that the federal government has no authority because it's a religious ceremony and because God is involved. Can either say yay or nay. And two, a union between two people. How should it be perceived? Should it be perceived only as marriage between two people, or should it be perceived as a union? Should they have to get legal paperwork or licenses to form the union? Well, it's like the same thing if you're going to do a partnership. You have to get legal paperwork. They aren't married. They aren't going before a religious. Federal government says, hey, this is a legal business partnership. The state sets up the regulations, and this is how it works. Well, a union between two people. What is a union? And it could be very similar to a marriage license, or it could be, quote unquote, a marriage license slash union. It could be a marriage slash union license. Then it can be used for both. Once the seal of the state or the endorsement of the religious organization is upon that marriage license slash union, marriage union license, whatever you want to word it, either the courts or the religious organization has endorsed it, it becomes a legal binding document that can only be dissolved through divorce proceedings. Bottom line is, the federal government with marriages has no authority, cannot try to even exert the minute form of authority. But the union between two people, the benefits and privileges, the federal government does have their grounds there. But the wording has to be such to keep it away from religion, but as individual citizenships and the union of two citizens. So that's what it's about. Okay? That's where I feel the dilemma the Supreme Court has. Two separate issues, two separate items, and they must be separated. And that separation must be maintained above all else. Marriage is a religious ceremony, therefore the federal government has no authority. The union between two people is a union between two citizens to become treated as an individual or to be combined as one. That is what is being discussed. That's where they have to draw the line. They got to separate marriage and union, and therefore the marriage portion of it, federal government has no authority, and the union, they have to define what is and how it is to be made and how it is to be dissolved. Thank you. This is JD. You have a nice day.